the relevant know-how or information has been obtained from the trade secret holder against its will by a third party through dishonest means. The assessment of whether and to what extent such restrictions are necessary is subject to judicial control on a case-by-case basis. This means that competitors are free and should be encouraged to develop and use the same, similar, or alternative solutions, thus competitive innovations, but are not allowed to cheat, steal, or deceive in order to obtain confidential information developed by others. Becoming aware of the importance of know-how and trade secrets, the Commission of the European Union adopted in 2011 a comprehensive IP strategy undertaking to examine the protection of trade secrets. A first study was published in 2012, providing a comparative law list in the situation in the member states. A second study published in 2013 with a main emphasis on the economic importance of protection. Now, it was not very astonishing that the evaluation of the legal situation in the European Union revealed a very colorful landscape. There is a lack of a uniform legal regime in the European Union, as you see with this flag design. For historical reasons, the current situation at EU level is that the legal protection afforded to trade secrets by member states varies significantly. Sweden is the only country with ad hoc legislation on trade secrets. All other member states offer protection to trade secrets through various pieces of civil and criminal legislation. Countries such as Austria, Germany, Poland and Spain strongly rely on unfair competition law, while Italy and Portugal have specific provisions on the protection of trade secrets included in their respective codes of industrial property. France has specific provisions on the protection of manufacturing trade secrets, also included in its code of industrial property. Tort law is also widely used to protect trade secrets. In particular, as we already have heard from James, in the Netherlands and Luxembourg, this represents a preferred option. Tort law principles usually exist for purposes of quantification of damages in the form of damnum emergens and lucrum cessans. In common law countries, such as the United Kingdom and the Republic of Ireland, that lack any specific legislation, trade secrets are effectively protected by the common law of confidence and by contract law. This is also the case with Malta. You see here a table giving an overview of the available civil remedies in the EU jurisdictions. I can't go through it. It would bore you, presumably, but as I offered, I will send you these foils. Most member states, with the exception of Cyprus, the Czech Republic, the Republic of Ireland, Luxembourg, Malta and the UK, have specific provisions on trade secrets in national labour laws or in their civil codes. Indeed, misappropriation by disaffected employees is widely recognized as a critical area for trade secret protection. The minimum common standard is the prevention of trade secrets and confidential business information disclosure by employees, at least during the employment relationship. Moreover, there is no uniform definition what it has to be understood by, under trade secrets. Despite the lack of uniform definitions, the review of the European Commission regarding the situation in the member states has shown the recurrence of certain common requirements to qualify information as trade secrets. First of all, it is technical or commercial information related to the business. Second, it is secret in the sense that it is not generally known or easily accessible. Thirdly, it has economic value consisting of or conferring a competitive advantage to its owner. And finally, it is subject to reasonable steps to keep it secret. Moreover, there is a lack of common instruments to enforce infringement of trade secrets. The main factor that hinders enforcement of trade secrets in courts derives from the lack of adequate measures to avoid trade secret leakage in legal proceedings, as we have just heard about the situation in the United Kingdom. This issue is a key factor because typically the plaintiff must substantiate its claim by disclosing the allegedly infringed trade secret. Disclosure means it's no longer a trade secret. Civil proceedings in all member states are public, and national procedural laws include provisions which allow courts to exclude the public from the hearing only for reasons relating to security, public order, or indecency. The right of a party to request that the entire proceedings or part thereof be heard in private to preserve confidentiality of the trade secrets exists only in a few jurisdictions, namely Bulgaria, Estonia, Hungary, Germany, the Netherlands, Poland, Romania, Slovakia, and Slovenia. But even where this possibility exists theoretically, it is seldom applied in practice, and no case law is reported on this point. Only Hungary, through in-camera proceedings, it does not astonish, Germany through the so-called Düsseldorf procedure, and the UK by means of a specific agreement between the parties limiting the duty of disclosure, seem to have in place effective procedural measures to prevent disclosure of trade secrets in the course of civil proceedings. I was told that we have a bit more than the originally planned 20 minutes, so I may briefly explain the Düsseldorf proceedings. The Düsseldorf procedure, which was originally developed in patent law claims, but is applicable also in trade secret matters. It consists of a procedure where courts order independent proceedings for the preservation of evidence by means of an interim injunction handed over to the defendant together with a statement of claims so that there is no chance to destroy evidence. The evidence is then examined exclusively by authorized experts and attorneys bound to confidentiality. As an attorney involved in these proceedings, I must not reveal any information to my client which might be revealed through these evidence-securing proceedings and which might be of advantage to the client. The parties themselves don't have access to the documents secured. Finally, a criminal law. Some of the member states provide criminal provisions. Again, you have here a table. And likewise, in civil law, the first factor of divergence is the lack of a common definition of trade secrets. As a consequence thereto, the extent to which violations of trade secrets are criminalized varies significantly. This caused the Commission to provide a proposal for a directive of the European Parliament and the Council on the protection of undisclosed know-how and business information. The objective of the proposal is to ensure that the competitiveness of European business and research bodies, which is based on undisclosed know-how and business information, is adequately protected and improves the conditions, frames framework of the development and exploitation of innovation and know-how transfer within the internal market. Specifically, it aims at improving the effectiveness of the legal protection of trade secrets against misappropriation through the internal market. In November and December, the trilogue meetings between representatives of the European Parliament and the European Commission have taken place. On December 15th, those representatives came to a so-called provisional agreement on the final text of this regulation. The full European Parliament and the full Council now have to agree on what is proposed, and then must be passed by Parliament. If once it is passed by European Parliament, the member states will have a period of 2 years to implement the conditions the regulation sets up into their national laws. The European legislator has no competence to set up something like the community trademark system or the community design system, because of the civil and criminal law aspects in the trade dress protection. Civil law and criminal law is not subject to the deciding authority of the European institutions. No, sorry. Now, as I mentioned, the regulation provides the minimum conditions the member states have to observe when they adopt their national systems. For this reason, first of all, the Commission proposal provides a homogeneous definition of a trade secret. Furthermore, identification of circumstances on which legal protection is justified. Provisions of corrective measures, but only in a general description, factors for calculation of damages, and under which circumstances court decisions may be published. Again, you may find some, I've prepared some foils which unfortunately have not been handed out to you. Article 1 defines the subject matter. One of the most important articles is Article 2, defining trade secrets, trying to safeguard that there is a common definition throughout the European Union, following the principles of Article 39 of the TRIPS Agreement. And Article 3 is of equal importance, defining unlawful acquisition, use and disclosure of trade secrets, under which conditions adoption of trade secrets of others have to be sanctioned. Unauthorized access to or copy of any documents, objects, materials, substances, or electronic files lawfully under the control of the trade secret holder, containing the trade secret or from which the trade secret can be deduced. Of course, obtained by theft, bribery, deception, breach or inducement to breach of confidentiality agreements, or any other contractual obligations resulting in secrecy obligations, and any other conduct which, under the circumstances, is considered contrary to honest commercial practices. Again, this is an open door for applying the national law, the national customs, what has to be regarded as honest commercial practice. It continues, I won't go through it. You also will find it on the website of the European Commission. The Commission has published, of course, the directive as it is concepted at the moment. Now, Article 5, general obligation, and this shows the problematic movement of this case. Member states shall provide for the measures, procedures and remedies necessary to ensure the availability of civil redress against unlawful acquisition, use and disclosure of trade dress. The measures are not determined by the regulation. It is up to the national legislator to provide effective means in order to safeguard that the aims of the regulation is achieved. And in this context, it is extremely important to mention that the enforcement directive, enforcement of intellectual property rights, give guidance in that direction, what has to be understood under the necessary measures, procedures and remedies in order to fulfill the obligations arising out of Article 5. Before I finish, let me allow to make two final comments on two important aspects which have been changed at the very last minute in the December 15th agreement. This relates to the whistleblower provision, and which relates, and a further amendment relates to the problems involved with employments. Now, originally, as regards employment, we have heard already that employees are the most crucial carriers of know-how. How to deal with employees changing the employer and carrying with them naturally not only obvious information, obvious knowledge, but also business secrets. And originally, the directive provided a restriction which said not imposing restrictions which must not affect the use of information. The use of information, knowledge, experience and skills honestly acquired by employees in the normal course of their previous employment. This would have meant that any information the employee carried along with him or her could have been used within the next employment engagement. And this has now been changed by the following wording: nothing in this directive shall be understood to offer any ground for restricting the mobility of employees, in particular in relation to the exercise of such mobility. This directive shall not offer any ground for, now the obvious, limiting employees' use of information not constituting a trade secret as defined on point 1 of Article 1. This is obvious. And now the more important section comes. Limited employees' use of the experience and skills honestly acquired in the normal course of their employment. And thirdly, imposing any additional restrictions on employees in their employment contracts other than in accordance with union and national law. And again, here we have the possibility to impose through labor contracts, as far as this is possible to conclude individual contracts because of union restrictions, to impose on employees certain restrictions with regard to trade secrets. With regard to the whistleblower provision, it was originally possible that the whistleblower could reveal many information, regardless how the whistleblower obtained it, all information, even not required for the purpose the whistleblower had in his mind. And now the publication of secret information obtained, of course, only on a legal way, must only occur to an extent which is justified by the intended purpose of the publication. Thank you very much for your attention.